have two speakers, Eleanor Solomon and and we're expecting someone from Brent Council as well to join us shortly. One thing I will say is that we're going to be recording this to put on our website and live streaming it on YouTube. So if you're on here and you don't want your name to be displayed anywhere, that's fine. You don't need to. Your name won't appear anywhere. If you would like to ask a question that our panelists can answer, then you can use the Q&A function to submit a question. You can also use the chat as well, but your name, if you're chatting with the room as a whole, your name will appear there. So if you want to stay anonymous, completely anonymous, use the Q&A. So I think we're so yeah, we should hopefully have Teresa from Brent very soon, but I think we can probably just kick off the session properly and start recording. Hi, my name is Dan Wilson-Craw. I'm Deputy Director of Generation Rents. This is the second webinar of Renters' Rights Awareness Week 2022. It is all about repairs, what to know if you're a renter and your home has something in it that needs fixing. We've got two speakers who are experts in the field, who can share their knowledge, tell you about what rights you have and how to exercise them. So I think we're going to start with Eleanor Solomon. Eleanor is housing specialist at Anthony Gold Solicitors, and later we're going to be joined by Teresa Hander, who is enforcement manager at the London Borough of Brent. We're going to be hearing from them for about 10 minutes each about what they do, what their work entails, and how they work with renters, and what you as renters need to know about issues that you might face with repairs. Once they finish their opening presentations, there'll be an opportunity to ask questions. So please use the Q&A and the chat to submit those, and we'll work through them. So thanks for joining, and we'll get cracking with. I'll hand over to Eleanor now who's got some slides.
Great.
Let's take over. Thanks.
Lovely. Thanks very much, Dan. Sorry, let me share my screen. There we are. And okay, that's great. Can you see my slides, Dan? Yeah, lovely. Okay, so I'm a solicitor at Anthony Gold, and a large part of the work I do is on behalf of tenants to enforce their repairing obligations. So what I'm going to be talking about today is that the rights you have as a tenant that you can enforce against your landlord, and these are mainly contractual rights and also rights in what's called the law of tort. So in the kind of briefing, it mentioned that we'd be talking a lot about the Fitness Act, which is one of the areas of law or ways that you can bring a claim against your landlord, but there are lots more legal routes into making your landlord do repairs. So these are the various bits of key legislation or ways in. The first one is the tenancy agreement. The second most important one is the Landlord and Tenant Act 1985, which incorporates this Fitness for Habitation Act. And then there's also
Eleanor, sorry, would you be able to start a slideshow so we can see the slides a bit larger on the screen?
Oh, sorry, I thought that's gone on a different screen. I do apologise. Let me see if I can just move my slideshow to. Let me just stop sharing and I'll share the other screen.
Thanks, sorry about
that. I thought that was the right one that I was already doing. There we go. Is that better?
Great, yeah.
Yeah. Okay, so always start by, so your landlord isn't responsible for repairing everything that breaks in your house. even if it's theirs and they own it. That doesn't mean that you have to repair it if it breaks necessarily, unless you broke it. But it also doesn't mean that you can force your landlord to repair it. It just means nobody has a legal obligation to enforce anybody else to do repairs. So when working out what they have a right to repair, the first step is by looking at the actual tenancy agreement that you have, because that might say some specific things that your landlord has to repair that there's no other legal obligation for them to repair. So it might say that they have to repair your fridge or washing machine or that kind of appliance, which otherwise they wouldn't have an obligation to repair. And it also might have some kind of wording about putting things in a good state of repair or putting things in a good condition, which goes above and beyond what the kind of standard legal position is. If the tenancy agreement says that your landlord doesn't have to repair anything or that you have to repair things, that is probably just null and void, but it can give you extras over and above what you might otherwise have. And then, oh, sorry, now I've done this, it won't go on to the next slide. There we go. And then the next kind of legal place to look is Section 11 of the Landlord and Tenant Act 1985, which was the kind of old pre-2020 rights of repair that landlords had. And then since 2020, the Fitness Act has come in and been incorporated within this act. So you can find both bits of legislation under Section 11 of the Landlord and Tenant Act 1985. And this applies to any tenancy of less than 7 years. So what that means is that the fixed term of the tenancy is less than 7 years. It could be that you have a periodic tenancy which goes on for more than 7 years and you've still got the repairing obligations, but it doesn't apply to a kind of long lease essentially. And it doesn't apply to a license either. So if you're a lodger, if you live with your landlord, it's quite likely that the only repairing obligations they have to you are what's written in the written agreement. And none of this applies, but if you're a tenant, it will. And the landlord can't contract out of this. They can't just say this doesn't apply because it still will. And what it says is that the landlord must repair the structure and exterior of the property, which is the roof, the walls, the windows, the gutters, the downpipes and the drains. And they must repair the water, gas, electricity, sanitation, all these kinds of things. Landlords are entitled to know about the issues in most cases before they do anything. So you have to tell them, and you should tell them in writing so that they have evidence that you've told them. And they're entitled to time to carry out the repair if it's inside the property. And how much time they're entitled to depends on what the issue is. So if the issue is no heating or hot water in winter, then a reasonable period of time might be 1 day or 2 days. If there's a kind of escape of boiling water, then a reasonable period of time might be hours, just to stop that and make it safe. If the disrepair is subsidence, then a reasonable period of time might be 2 years to monitor the cracks for a year and then sort of tender out for really, really major works. So it really depends what the issue is, but they should get started with the job pretty much as soon as they hear about it. And then the Fitness for Human Habitation Act goes up above and beyond the other legislation, which just says that they should fix things as they break and only certain things. And it's much wider, and it says that a dwelling, so a house or a flat, is fit for human habitation at the beginning of the tenancy and continues to be fit for habitation. This is what should happen. And it's unfit for human habitation if it is so far defective in one or more of the following matters, which I'll go on to, that it's not reasonably suitable for occupation in that condition. So this doesn't mean it has to be uninhabitable, unlivable, which is a very, very high bar. Indeed, it means it's not reasonably suitable for occupation. So it might be uncomfortable, unpleasant, causing health problems like mold might do, that sort of thing. And it has to relate to one of these issues. And these issues cover, as far as I can see, almost everything that might possibly be wrong with a property. So a repair issue, anything needing repair, not just those specific issues covered by Section 11. Stability, so structurally, freedom from damp, internal arrangement, natural lighting, all these things. And then lastly, a prescribed hazard. And then for a prescribed hazard, that is in different legislation in the HHSRS, in the Housing Health and Safety Rating System. And this is very, very extensive. It is under review at the moment, so it might be kind of summarized, condensed a bit, but there's 29 hazards. I won't go through all them now, I'll just click through them, but they do cover almost everything that I can possibly imagine that might be wrong in a property, from kind of repair issues to entry by intruders. So that might be your front door lock being broken, noise, that might be and it is, the noise from the road or from the boiler is very, very loud because of something to do with the property. Food safety, that might cover something to do with kitchen cabinets or not having a sink in the kitchen. There really is a huge amount of ways in which something can be unfit for human habitation. It doesn't apply if the tenant has failed to use the property in a tenant-like manner, which means the manner of a good tenant. So, for example, if the tenant has hoarded loads of items and caused a rat infestation, then the landlord can't be sued for the rat infestation. If the tenants breach their own obligations, if the tenant is supposed to do the works themselves, so like they're very minor works like unblocking a sink, the landlord also doesn't have to rebuild or reinstate the whole building if the whole thing falls down, or repair anything the tenant is entitled to remove, so something like the tenant owns. I mean, obviously, as you can imagine, this is the kind of where arguments happen, because the landlord will blame the tenant for failing to use a property in a tenant-like manner. The tenant will say that they didn't. But these are the kind of the ways that the landlord gets out of doing works under the Fitness Act. They do extend to communal areas as well. But if your landlord doesn't own the communal areas, so for example, a communal corridor in a block of flats and your landlord just owns one flat, then the landlord's obligations are quite limited to asking the freeholder to do it, basically. So very, very quickly, what can you do? Firstly, don't withhold rent. If there are repair issues, I know it's tempting, but then your landlord will just sue you for the money and take possession, and you'll end up having to counterclaim, which is a lot less of a stronger position than claiming. And also, if you withhold all of your rent, that will almost certainly end up being more money than you would have been entitled to in a damages claim for the disrepair. Do complain to your landlord in writing and do keep records of that. Do give access for works, and your landlord has to ask for access on 24 hours written notice, which isn't very much, but you are supposed to give access if that's requested, and written can be a text message or an email. And do report the problems to the council. Firstly, as if there's a category one hazard, they can force the landlord to do works. But secondly, it can also just provide quite useful evidence for your own dealings with the landlord if the council goes round and writes down what they think is wrong with the property, because it's not always easy to tell. Do check whether your landlord has an HMO license, and if they need one, which you can find out online, and potentially you can report them. If they don't, that's not directly related to the repairs, but it can be a good negotiating tool. And do consider bringing a claim, either via a solicitor or your own small claim if your landlord's in breach, especially if the kind of repair issue is quite obvious and doesn't need complex expert evidence. And that's a complete whiz through this repair.
Great, thanks very much, Ellie. That was really really helpful, and I'm pleased to say that we now you mentioned going to your council with a problem. Would you say that that speaking to the council kind of should be the first, well, if your landlord hasn't taken action, that would be a...
Yeah, I mean, obviously complain to the landlord probably several times first, and make sure that you've complained in writing and that you have a note of that. I mean, depending on how serious it is, if it's very, very serious, then complaining once might be sufficient. But beyond that, and beyond raising it with the landlord, then I would say going to the council should be definitely the second port of call. Yeah.
Well, I'm pleased to say that we're joined now by Teresa Hander from Brent Council. If Teresa could join, great. We can see you now. Teresa, are you ready to present your slides and take us through the work that you do at Brent Council?
Thank you very much. And I've just sent it to, I think I've sent it to you, or shall I share my screen?
If you can share your screen, that'd be great. If there's a problem, then we've got the slides, so we can step in and I can share.
Give me a second. I'll try and work it out. I'm not sure I'll manage.
Yeah, okay.
Is it here? Oh, I can't.
Okay, I can I can share
If
my
you
screen.
don't mind sharing yours, would be great. Thank you.
Not at all. All right, here we go. Can you see that?
Yes, I can see that. Thank you. Thank you very much for inviting me. So I'm Teresa Hand. I manage the private housing services enforcement section. Sorry about my slide is a bit Brent centric, but I hope I'll be able to answer some of the questions that I was asked to present. Can I have next slide, please? So just to give you a little background, we are responsible for about 58,000 properties roundabout. It's a sector that's really growing in Brent, and when tenants contact us, we will respond to all tenants' service requests. So we will carry out any form or some form of investigation, rather, whether that's over the phone or we can come and visit you. But the main function is to improve private housing services. We do that mainly through what the first speaker was talking about disrepair. But our proactive approach is also through licensing, which I'll talk about a bit later. We also help tenants with adaptations. There are some tenants who've been staying in their property for a very long time and have some rights. They can benefit from some small work grants that we have. Yeah, so the next slide, please. I think the next one. So, sorry, Dan. Yeah, sorry, Dan. I'll just move on to the next one. Wish I could do my one. So, so the conditions of the hazards that are, when we come to inspect your property, we look at the whole property, whether you call us for any form of disrepair. What we are required to do by law is to come and have a look at the whole house and carry out what is called hazard assessment, which looks at all the 28 hazards that was mentioned earlier. And so we will come out, look at the property, look at who is there, and make our assessment. And then after that, the process we have is to send that report, a report of disrepair, instructing a landlord of what they need to do. We do that informally for a start, and we find that doing that informally for us, I know you were told earlier to report everything to the landlord. That's a good thing to do. First of all, report the disrepair to the landlord, because when the council comes in, the intention is to repair it at all costs. So first of all, we look at what is wrong, and then we will look at who is affecting, and then we'll send out a list of repair works to the landlord, assuming the landlord is the responsible person. Often the legislations that we enforce, the landlord is mainly the person to go to, or the person in control of the property. There are instances where the tenant or somebody else may be responsible, for instance, if it's the common parts, or as was said earlier, where there are other issues of mental health. So there's some hoarding or vandalism sometimes. So those ones the tenant will be responsible for. But by and large, the legislation that we enforce requires action from the landlord, and they'll be the first person that we ask for those repairs. So we will start informally. We find that that is better for tenants' relationship after we've gone, because what we don't want to do is to come in hard and force those repairs, and then the landlord is then annoyed and starts harassing the tenant. Of course, we can do something about that, but that is a nasty experience that you don't want to go through. So we try to get things informally done. We normally allow a reasonable period, which is 28 days often, depending on what is wrong. And if that doesn't work, then we'll go to our formal action. The formal action we take is normally to improve the property or prohibit it. Sometimes we just advise the landlord what to do if the hazard is not very serious. The next phase of enforcement would be, if the landlord doesn't do it, we will take enforcement action. So that will be prosecution, and prosecution will be to failure to do what the council has told them to do. Obviously, the property is still not improved, and by with that, we have the power, as I say, to either prohibit that property or to carry out works ourselves. And we have done that in a lot of instances where the landlord's disappeared or the tenant, there are other issues. So we can do works in default as well. Sorry, can I have the next slide? I think I might be in third. Yeah. The hazards will be mentioned there. There's a list of things. Don't worry about the kind of hazard. If you have disrepair, just report it to us, report it to the council. Most council will have a policy to respond to them. They have a duty, in fact, to respond to their residents. And it is up to, after that, they decide what to do. So any kind of disrepair that you have reported the landlord and the landlord has not resolved, send it to your local authority. If you're in Brent, send it to us. We've got the details there at the bottom, and we'll come and have a look and decide what to do. So that is just a list of the most common hazards that we deal with, which are quite serious, but there's plenty more, and we will advise you. So yeah, the next slide, I think, is the third or fourth. I should carry on mine. So that is the traditional enforcement. And as I said earlier, we also have, we operate licensing in most boroughs now operate licensing, and that is a shared house. Licensing is really, really helpful to tenants in particular, and for us local authorities, because it deals with management, poor management, which is the main cause of these repairs in Brent, certainly in Brent and in most rented sector, where somebody's rented a property, they're taking rent and they're just not looking after it. There's legislations there, that management regulations that we use. So we use licensing to proactively improve standards. And what happens is the tenants will have a bit more rights within that setting. In that, for instance, for us, we will require the manager to provide a written agreement to the tenant as part of licensing conditions. I know there are other avenues where you can do that, but we can at least enforce that it has to be a written agreement, even if it's not AST. There is also amenity standards. So not too many people in Brent, we have 5 people per amenity. Amenities, bathroom and toilet and kitchen and things like that. So 5 tenants per a single amenity. Reduces overcrowding as well, so we got all powers to reduce that. The other traditional means of enforcement is more powerful, but it's very tedious, it's very long process. This one is very quick, and we have it in Brent. We have borough-wide additional licensing as well, and mandatory, so we use that to improve properties. So if you are living in a shared house which is not licensed, you can report it to your local authority, because the offense there is very serious, and depending on the circumstance, the tenant can ask for their money back. Rent repayment orders apply in that kind of offense, which is really helpful. And also, even if you don't apply for it, you can use it to negotiate some better terms for yourself once the landlord is caught. We encourage tenants to really look into it. So yeah, so that's the benefit of licensing, which I have sort of run through. But the other thing I can do, so what can tenants do? The things that I would advise, as was advised earlier, is report first to your landlord and try and get them done in a friendly way. If that doesn't work, then report it to us. But the other thing also is, when you're moving in, just check what you're signing up for, because mostly people call the council after they've agreed to some conditions, which we then can't really help with. So check what you're signing up for. Most local authorities, certainly in Brent, we have a list of landlords online where we have prosecuted them. We've got those details online as well. So have a look and check whether the agent that is you're entering into agreement with has got any conviction or is listed there as a rogue landlord. If you're paying cash, most tenants do, some do. Make sure you get some receipt or pay by bank transfer if you can. If you can't, then get a receipt, or at least get the details of the person who collects rent, because when the council comes in to try and help you with any disrepair or lack of licensing, we will want to know who is collecting rent, because that's the first person we go to. Any cooperation you have, once the council comes in, try and cooperate with the council. Get them what they need, because the intention is really to help you. Yeah. So and check with the council. You can always ring the council to ask about details of a property that you're moving into. If it's a property perhaps that we have banned, or we have served a prohibition order, or we seem to be taking too much action on, we can't tell you about it. Then you can make a decision at least once you know what is happening there. So I think that's probably my time. I'm really sorry that it's really rushed and didn't have my slide. But if you have any questions at all, in Brent, you can call us, you can report it online. Most local authorities, I think, will have online reporting forms as well. But my details are on that slide at the end, where if you have any questions, even later, I'm happy for you to contact me. I'll try and answer. Thank you very much.
Great, thank you very much, Teresa. That was really helpful and great. Great to see that other side of things, what councils are doing. I wonder if we can get Eleanor to rejoin us on video, and I can talk essentially. Well, if we can have both of you on.
Okay.
On this, yeah, that's all right. And I'm going to kick things off. I've got a couple of questions, but if anyone who's watching has a question you'd like to put to our panelists, please use, as I mentioned earlier, the Q&A, ideally, or the chat. In the chat, we can have a bit more conversation, but your name might appear for others there. I suppose one. We're talking about reasonable times. I think it sounds like having. If something's a sort of an immediate threat to health, that's that warrants much quicker turnaround time in terms of tenants reporting something and kind of having to wait for a landlord. But is there a particular is there a reasonable time for just a I suppose for a hazard, something that the landlord should be fixing, but maybe is not an immediate threat to life or health? Is there a particular sort of benchmark that you should be looking at?
I mean, so under the Landlord and Tenant Act and the tenancy agreement, the reasonable time as a phrase is an implied term which comes from common law and from case law, and it's really nebulous, and it's not really looking only at safety but also at just how long it's going to practically take to do a particular piece of work. Not to say that the landlord can use an excuse, I tried this plumber and they let me down and I tried another one. It's more looking at, if you employed somebody and it all went well, how long would it realistically take? You need to get scaffolding licenses from the council to put scaffolding up. Is this something that you're going to have to put out to tender? So unfortunately, it is something which is just really, really dependent on the scenario. But I would say in general, for something that was fairly standard and neither a huge risk to health nor really major, 2 or 3 months would probably be almost in excess of a reasonable time.
So after that time, the council should be involved, or? Well,
I mean, there's two different things being conflated here. The phrase "a reasonable time" comes not from any of the council's powers, which are under the Housing Act 2004, but rather from common law and the contractual tenancy agreement issues. So after that period of time, you in theory could bring a private claim against the landlord. The council will make a decision about when to get involved, far less based on how long things have been going on, but more on how dangerous things are as a hazard.
I see.
Yeah. Sorry.
Go on.
No, I was just going to clarify that. I know I say 28 days, but that's because of the kind of hazards that we deal with. It's true, the reasonable period is just what works, how much time the landlord needs to have, requires to prepare for those works. If they're getting quotes and things like that, take into consideration. If they're things that are not serious, then really the council can't even demand a time limit on it, because clearly, it's not really something that we're going to enforce on. So we would deal with those, but will be informally, because that's the only way it will work.
And if a landlord is one of the things you mentioned, Teresa, was that you'll write to the landlord before taking formal enforcement action. if a tenant's been emailing and calling the landlord for sort of several months, maybe before they contact the council, does the council kind of take that into account in terms of sort of the time that you give the landlord?
I think it's going to be more on the seriousness of the hazard, really, and a little bit of how much the landlord has been aware of it. So we have the informal period, negotiating with the landlord. Can you please do it? If the tenant can show that they really have done this for 3 months, then we may not do that at all. Where the hazard is serious, we can just go in and do our statutory duty, which is take action. So yeah, it's going to be dependent on those two things: seriousness of hazard and also a landlord. And if he's a landlord that we know is quite bad, then we won't give them more time. We'll probably start pushing them as quickly as we find out.
Yeah, thanks, that makes sense. And one of the things that we've had in law since 2015 is a protection from the Section 21 eviction if your landlord serves with an improvement notice. Do you get many cases where the tenant has been served Section 21, or is worried that there's Section 21? Does that inform your decisions?
Well, where the tenant, a landlord will have a right to serve an eviction notice. But first, we'll just find out if it's been done lawfully. Where we've been and we've taken action, and then a landlord serves that notice, then we will be concerned, really, and we'll look into checking whether is it as a result of our action. And that, I believe, I'm sure Eleanor will say, there'll be some protection given to the tenant with that action that we take, the improvement notice. So we can defend that, and I think I'm dealing with one right now, actually, and it's becoming a lot more common, unfortunately. So, but yeah, once we've taken action, we've gone there. Well, if we go there, first of all, we find an unlicensed property, the landlord is prevented from serving that notice in the first place. So this is one of the benefits as well for licensing, where we've gone in and served an improvement notice. Again, there is a time limit before they can serve that notice. But if a landlord has served a notice before we get in and has followed all the protocol, then of course that we don't interfere with that.
Right, I see. So, so even if there's a hazard in the property that warrants an improvement notice, then the council wouldn't step in.
If it's a fair eviction process, then no, and we shouldn't really. There's impartiality required from the council as well. We will look at the hazard. The property is going to be improved whether the tenant lives there or not. And if it is a serious hazard, then we'll still take action alongside that eviction process. So it doesn't really interfere with that process. They're two different things, aren't they? Because we'll still require works, unless the landlord can prove that they need a vacant property, for instance, then we may allow that process to end before we serve a notice. Otherwise, we don't really.
Right, and so I'm hogging the questions here. One of the things that some tenants come to us and with concerns about is when they've spoken to their landlords, the landlords ignored a problem. They've then taken that to the council, and the council has said, "Well, thanks for letting us know. We're going to let your landlord know that we're going to inspect the property." Is that something the council always have to do? I think when tenants tell us about this, it's because they're kind of worried about how the landlord will react if the council comes in and inspects the property. The landlord might wish to be there when the inspection happens, and that tenants can kind of feel quite intimidated in that situation. Is there anything kind of that protects tenants in that sort of scenario?
We'll get that view from a legal point of view. But for our process, first of all, I think the law Housing Act requires us to inform the owner and the manager at least 24 hours before we visit. Otherwise, we can't take formal action. But of course, we can carry out an inspection without telling the owner, except if we were to want to take that action further action, as in force them to do it, then we have to start again and inform them. It's always sometimes it can be a problem, and I can understand why. So with our officers, we ask them to let the landlord know, but get permission from the tenant first before we go with the landlord. We've got two types of inspections. We've got inspections where a tenant has called us in. They tend to be quite difficult. And often the landlord stays outside as we go in and then carry out our inspection. And then we come out and have a meeting with the landlord separately. Where it is a licensed property, then we need the owner or the manager to be with us because there are loads of rooms. We want access to them. The reason why we prefer to go with the landlord is because a lot can be done. As I said, a willing landlord will do a lot more than the law requires. Law is, the local authority will have powers, the statutory powers, which is to reduce the hazard, not remove the carry out repairs. Do you know what I mean? So we try to work with landlords informally. If they are there and I point out this needs to be done, how long? They tell me 4 weeks. I give them 4 weeks, and if I think it's reasonable. So where it works really, really well, and we leave tenant and landlord both happy and clear on what they're doing. Obviously, sometimes it doesn't work.
Thanks. Right, I'm going to have a look at the questions that we've got. A few questions on the Q&A now. This is a question for Teresa. Sorry, Helena. It's related to licensing. Do you know roughly what percentage of private sector properties in Brent are not licensed when they should be licensed? Are there lots of HMOs or other properties in selective license areas that are not licensed?
I don't know this percentage because I think what I know is the number that we license per year, and we have 4,000 selective properties licensed every year, and about 4,500. 4,000 is our target. We normally pass it. We have a target of 1,500 HMOs per year that we license. Again, we always meet that. And actually, if you look at I don't have the percentage, I'm afraid, but we're doing very well in Brent. A lot of our landlords are quite willing to license their properties. It's the maintenance of them that we have a problem with. If you compare us to other boroughs, I think we are nearly third in London as the highest number of licenses. So we're doing very well in that regard. We're also doing very well with the enforcement of those who don't comply. I don't have the right figures. I'm sure I have them in my computer somewhere, but or online. In fact, we may have it online as well. Yeah.
Thank you. I'm going to read out this question, which is about adaptations and accessibility issues. So hopefully, well, I'll see who wishes to answer it first. How about accessibility issues and minor adaptations to add a shower grab rail for mobility impaired individuals? What if it takes 2 months to agree to it, with early correspondence within the fixed term from landlord via letting agent to ask me to move out? The council occupational therapist was copied in on allow this and agreed with me was wrong. How can we avoid this happening to others? Even though it was still wrong to do it with me, I persevered and got what I wanted, but it was the method of achieving it. But the method of achieving it was wrong. What advice would you give to others in similar situations? So I think, well, this person was kind of forced to be moved out in order to do it after asking for an adaptation. But what advice would you both give someone in a similar situation?
I mean, adaptations, if you're a tenant, the landlord has to agree. And that's where the delays normally is. I mean, first of all, you'll have to qualify. Most tenants, some tenants will qualify. But the landlord, the owner of the property, has to agree, for instance, to, if this is adaptation, for instance, to level access shower, for instance. If they don't agree, then there are things we can do. It takes so long, it really does. So the first thing I would say is talk to your landlord, nice about it, knowing that they can say no, because if they say no, that it may even be reasonable to move the person out if they say no, because some landlords just don't like adaptations to their house at all. So consent from the landlord is the one that we find causes more delays. It's not quite my area, but if the assessment itself is a very straightforward case, once an officer turns up and does the assessment, and the OH does the assessment, then the process is very smooth. But we find that with the landlord and the tenant, that relationship prior to us coming can be tricky and can delay things.
Right. Yeah. So I guess from a legal perspective, this question is split into two parts. There's the council that might give the grant funding to get the adaptation, and then the landlord has to agree, or they can refuse in specific situations. So, for example, if the adaptation is something they'd need planning permission for, or if it was really, really major, or if it was going to kind of devalue their property long term, something like a shower grab rail, I can't see any reasonable reason for not agreeing that, and it should be done more quickly. In terms of it's just a pain. It's, you know, in theory you might have a claim under the Equality Act if the landlord left this for a really long time. 2 months, even though I'm sure that was a long 2 months for you, is probably not going to be enough for any kind of claim. There was a government consultation on this exact issue very recently to try and change the law and streamline the process for adaptations to properties and how the Equality Act works. So if we're being optimistic, we might see some legal change and the change in the way this works coming up, but that's probably not going to come in for years, if at all.
And thanks. And it's probably worth mentioning that obviously the Renters Reform Bill, by abolishing Section 21 and changing evictions in that way, should, you know, we've always argued that should give tenants more confidence to make those requests. We've got another question which I'll read out. I've been waiting 5 weeks plus now for my letting agent to repair a leak/dampness. I have a recurring damp patch in the same place, but at the same time, in heavy rain, it now forces water to run down an internal wall. I go through the same thing every time there is heavy rain, and the letting agent is slow to follow up or reply. I only ever deal with them by email for this reason, but I've now sent 6 emails. They reply to every other one, never follow up to see if any work has been done, barely communicate with me. Electrical testing is 3 months overdue, and they haven't even communicated on interlinked smoke alarms. I'm worried about complaining to council in case letting agent makes life difficult for me. I can't move because there is nowhere to move to. I think, I mean, in this situation, with an individual case, I mean, there's only so much we can ask you to advise, but I think, yeah, I would say, first of all, I'm going to invite our panelists to sort of say kind of what principles tenants in the situation would follow. But I should say that on our website we do have links to advice organisations who could potentially help with this.
Yeah, sure. So, I mean, Section 11 of the Landlord and Tenant Act and quite possibly the Fitness Act would apply here. So it says you've been waiting 5 weeks plus, but it sounds like this is something that's happened before and it's just come back again, which might be seen as the same ongoing issue. So it might be that you had a claim against your landlord and could force them to do the works properly, and likewise, obviously, to go to the council. In terms of being worried about complaining to the council, I'm sure bringing a claim would be the same thing, that you'd be worried about a retaliatory eviction. And obviously that is possible, unless the council were to serve an enforcement notice and stop it. I mean, you can try and protect yourself from that by complaining to the council, and then if they later served an enforcement notice, you'd be protected from a Section 21 eviction. But short of that is a real risk, unfortunately.
Yeah, I mean, we do class leaks as urgent calls, so we'll come out very quickly. Often, depending on what is happening at the time we visit, if we find a leak that is happening, we always use a different legislation to the Housing Act, which is it's a different legislation, which can be quick. Very tricky, but it's quick. EPA, we call it. It depends really on environmental protection. So yeah, right. It depends where the leak is coming from. I think before we consider that, it will depend where the leak is coming from, if and how serious it is. Before, to serve that. If the leak is coming, if it's rainwater and it's coming from disrepair, for instance, it's easier to deal with. If this, and may well be the owner of that premises responsibility. If it's coming from a roof, for instance, then it's somebody else's problem. It's somebody else's responsibility. The landlord is just as victim as the tenant. Tenant obviously experienced really a lot more. So our investigation will look into that. But it is a serious thing for us because, as you say, there are other hazards that can arise from it, electric hazards, and obviously a lot of damage to the tenant property. So we will come out in Brent, we'll come out within 2 days. If you call us when it's raining, we can accept video calls, which will then help us with where to look for the source of leak, for instance, if it's rainwater. And so, yeah, look at the whole property. If we come after the leak has stopped and we are now dealing with the remnants of it, for instance, the damage to the walls that is now not energy efficient because they're so wet and getting mold, then we'll use the Housing Act. That's a lot more, constructed and a lot more. A leak that happens once is unlikely to cause Category 1 hazard, which uses power. But so it's better to call the council when it's happening, is what I would say. The council will then look at it, look at the source of it, look at where it's coming from, and make a decision on it. But in terms of eviction, you can't live in a house like that when you're paying rent, really. So if they're not doing anything after 5 weeks, then tell the council and let the council know of your worry. Let them come and perhaps without a landlord and get the evidence they need, and then try and see if the landlord can do it informally. That's what I would do. Get the evidence I need, and then without telling the landlord, and then inform the landlord, allow them time. If they don't agree, then I can then take action very quickly, which has some little protection for the tenant. And at least, even if, they'll be breaking the law if they just evict you. I would still advise you to just let the council know if a leak has been happening for that long and they're not resolving it.
Thanks very much. That's really helpful. It's useful to know that those sorts of situations, it's worth contacting the council straight away. So that's sorry.
I just jump in to say that in my experience, there is a huge range of behaviours between different councils in how likely they are to enforce on different cases. And I don't know whether this is always going to be true in your local council, if you're not in Brent, that they would react that quickly, because there are some who are very on the ball and some who it seems to be quite a low priority for.
Well, we have councillors that put a really, if we know about it and we don't do something about it, we'll really get a lot of criticism for it. I can't promise that we'll visit. I mean, we are really short of staff at the moment, but the intention is always to visit as quickly as possible, especially when we get a video. All councillors as well, get a councillor involved, perhaps, that will kind of push things along as well. They're really good. Where your councillor is active, they're really good at getting the local authorities to do their work. I personally welcome their intervention, even though they can be annoying. But they do a good job. They really do. And sometimes they send us tenants that live in Brent. We have very poor housing conditions. That's perhaps why we respond very quickly to those kind of. They're not very serious hazard, but sometimes there's so many of them that is just really impossible to live in those kind of houses. So we're aware of it and we're trying to do something about it.
Right. So we've got 5 or so minutes of questions left. If you've got a burning question you'd like to ask, please put it in the Q&A or the chat now. I've got a few more that I'm keen to get some thoughts on from our panelists. One thing that sort of comes up quite regularly, and it can be quite not especially intuitive or not very obvious for a tenant, particularly if they're sort of a young tenant, if they're a student, let's say, as to if an appliance provided by the landlord stops working, what's the tenant's kind of responsibility to check that it's the fuse or even replacing light bulbs and that sort of thing. is that set out in law, or is it likely to be in the tenancy agreement?
So that's set out in various different pieces of case law, unhelpfully, but a tenant is responsible for minor repairs. So minor repairs would include replacing a light bulb, unblocking a sink unless the sink had some kind of more serious drainage issue where it just couldn't be unblocked, changing a fuse, certainly. I think that's bleeding a radiator is always put in there. I don't know how many people bleed their radiators, but that is the tenant's responsibility.
I think I need to.
Yeah, I really don't do it very often, or I've never done it. But yeah, these are the kind of examples, and they're annoyingly just kind of set out in different cases. Some of them from a very long time ago, rather than being in one nice place.
So, but that sounds unhelpful, but also quite interesting that it is actually set out in terms of what is expected of tenants and what isn't.
Yeah, that's right. So there's lots of cases that talk about a tenant-like manner, which includes being a good tenant, paying your rent, not damaging the property, telling the landlord when you notice something going wrong, and doing these kind of minor jobs around the house that it could be expected that anyone would do. I mean, in reality, I have definitely seen landlords do things like bleed radiators for tenants when they've complained about that, rather than raising this. I think landlords don't know that also the tenants are supposed to do it, but beyond that, tenants shouldn't be doing any other kind of repairs because they might not have permission to do that because it's not their property and they're not allowed to. But yeah, those specific examples are things that tenants should do themselves. Clearing gardens as well, anything like that, clearing brambles and things in the garden is something that comes up as a source of dispute quite a lot, which isn't the landlord's responsibility.
One thing that I remember doing a couple of years ago was replacing, basically the toilet seat had broken, and so we just thought the easiest thing to do would just be buy a new one, but presumably that might be a grey area.
Yeah, I mean, you probably could insist on your landlord doing it if you really wanted to, but equally, I think I would just replace that myself as well. Shower curtains, anything like that, that's just so I just probably just do it yourself. I mean, if you want to send the landlord the bill for your new toilet seat and you didn't break it through any negligence of your own.
It's wear and tear, like getting horrible and rusty because it's so damp in there.
Yeah, exactly.
I think sorry, I wanted to add this quickly that for local authorities, I know that law exists, but we look at the hazard. So if the radiator is not working because it's not been bled, the hazard of cold still exists, then there will be powers to take over there. It's such overlapping powers, as you know. There's and sometimes they even contradict each other. And we experience this in court where there's lengthy and a lot of money spent in this sort of argument. But essentially, at the heart of the Housing Act, I believe that it says there is something there, I think, in the old 1985 Housing Act, which was if the landlord provides it, then it should maintain it, I think. The Housing Act also deals with breaches. Sometimes, there's an argument of lack of. So if they don't provide it, is it their responsibility? But if it leads to a hazard, we will look at how we can incorporate, if it's serious enough, of course. I don't normally tell the tenants to do repairs because they do it so badly. And then the following month we go there and then there's this chat with the landlord about who did what. So I would listen to the legal advice that's just been provided, perhaps a lot more than mine. But the local authority has a duty, can have a duty in those cases as well.
Yeah, it is always a contested issue, especially with unblocking sinks is a really big one where this comes up, because the landlord is always accusing the tenant of putting something ridiculous down the toilet, which is often you just think, why would anyone put this down the toilet? And if you live in a block of flats, if you're unlucky enough to live at the bottom and you've got the whole stack pipe going all the way up, if anybody's put anything down the toilet, that's going to affect you at the bottom. And I've had the classics of nappies as the main one, but also a whole chicken once was alleged to have been put down the toilet and flushed, causing a blockage. So this is the kind of scenario where landlords will be blaming tenants, and you just you don't, obviously my client will always deny that they've put a chicken down the toilet or something ridiculous, and I usually believe them that they didn't. But these are the contested issues that come up quite a lot. And then often the landlords will say, well, tenants need to unblock the sinks, which is true the first time, but if sometimes there's a real major blockage, which is if you've tried it with a bit of a plunger and a bit of that liquid and it hasn't worked, then it becomes the landlord's responsibility, basically.
Right. Yeah, that's useful to know. Great. Well, I think, one, I suppose related to that, we've got 3 minutes left. You mentioned early on making sure you give the landlord access to make repairs. Sometimes one thing that comes up fairly often is tenants being away. They might be kind of nervous about letting other people in their home. What are the tenants' rights around that? And we've just got a couple of minutes left, so if that's something you can address quickly, that'd be great.
You don't have to let the landlord enter when you're not there, unless it's an emergency, such as a leaking pipe that they have to go and stop, in which case they can, if the tenancy agreement allows, enter without even telling the tenant and just break in and to stop it. But that's a really, really extreme emergency type scenario. But otherwise, the tenant has the right to be there, but they are supposed to give access on 24 hours written notice, which obviously in this day and age, if you're going to work, is almost impossible. So I find that usually landlords are a bit more reasonable than that and don't actually expect, if you say I'm coming around tomorrow, that you have to take a day off work and be in. But the legal position is that you should be, and that the landlord would have a defence to a disrepair claim if the tenant had repeatedly not given access to works.
I see. It sounds like something that's quite tricky and thorny issue, I suppose. If your employer is a bit more lenient on that side of things, then that sort of would help you out in that situation. Yeah,
exactly. I mean, obviously somebody else can be there. It doesn't have to be you to let them in. Lots of landlords won't do works without the tenant there as well. Equally, they'll demand that the tenant is there to avoid disputes, which becomes even more tricky.
Okay. Well, we're coming up to time. I should thank you both very much. Thank you, Alan Solomon of Anthony Gold Solicitors. Thank you, Teresa Hander of Brent Council. I'm just going to share one thing, just to let you know about what Generation Rent does, and how you can stay involved. So you can see that. If you enjoyed this session, please stay involved with the campaign. If you haven't signed up already, the link to sign up is right there. We're also really keen to hear your experiences of renting, particularly disrepair issues you've had. Our website, Vent Your Rent, exists for you to share those experiences. That helps us understand what sort of rights information we need to provide, and also, if there's a change to the law that we need, what we should be campaigning on. We have a renters panel, which is a very important part of our work, where anything that the government's working on, anything that we're working on that affects renters, our renters panel will take a look at it. We had a session a couple of weeks ago with the Department for Levelling Up about their plans for landlord registration. It's one way to get your voice heard and make sure that the officials and politicians listen to what you have to say. You can help us campaign online by signing up to volunteer with us. And finally, if you like what we do and want to help us do more, then please consider a donation. That is very much appreciated. Thank you for joining us. Thank you again, Eleanor and Teresa, for your amazing presentations and really valuable expertise. I've learned a lot. I hope everyone watching has too.